साइंश शॉर्टहैंड स्टेनोग्राफी सेंटर दिल्ली में आपका स्वागत है। आज डिक्टेशन नंबर 2 करने जा रहे हैं हम। लीगल डिक्टेशन नंबर 2। Heard learned counsel for the appellant and learned counsel for the State Bank of India. Full stop. Learned counsel for the Indian Bank and learned counsel for the resolution professional have also appeared. Full stop. This appeal has been filed against order dated 16/5/2025, by which an application filed by the State Bank of India under Section 7 has been admitted. Full stop. When the appeal was taken for consideration, learned counsel for the appellant had submitted that they have given fresh proposal to the State Bank of India, which was noticed by this tribunal on 30th 5/2025. Full stop. We noticed the said fact and passed an interim order directing the IRP to invite claims and collate claims, but not to constitute the COC. Full stop. Today, when the case was taken up, learned counsel for the appellant submitted that the OTS proposal has been accepted by the State Bank of India, and sanction letter dated 26/12/2025 has been received from the State Bank of India. Full stop. Learned counsel for the State Bank of India also submitted that the State Bank of India has accepted the OTS from the appellant. Full stop. Learned counsel for the appellant submits that another financial creditor, Indian Bank, has also been approached and a proposal has been given. Full stop. Learned counsel for the Indian Bank submits that the proposal of the appellant is under consideration. Full stop. Learned counsel for the resolution professional submits that there are other creditors, who have also filed claims apart from State Bank of India and Indian Bank. Full stop. Paragraph. In the present case, State Bank of India, who initiated the proceeding, has already been accepted the OTS which has been communicated by the bank on 26/12/2025. Hence, we see no reason to keep this appeal pending. Full stop. The course open for the parties is to file appropriate application under Section 12A of the INB Code. Full stop. The financial creditor, State Bank of India, submits that necessary form FA shall be given within 2 weeks to the resolution professional for filing Section 12A application. Full stop. Learned counsel for the appellant shall also approach the Indian Bank and take steps for obtaining settlement (OTS) during the said period. Full stop. We are of the view that an appropriate application under 12A may be filed by the financial creditor within 4 weeks from today. Full stop. The application under 12A shall be considered by the adjudicating authority and shall be decided in accordance with law settled by the Honorable Supreme Court in Company Appeal (AT) INS number 827 of 2025, 2 of 3 Glass Trust Company LLC versus by Jew Ravindran and others, 2024. SCC online. Full stop. It will be open for the resolution professional to prosecute the 12A application and take further steps after decision in application under 12A full stop. Learned counsel for the resolution professional submits that he has also filed an application for fee and expenses of the resolution professional full stop. It is open for the resolution professional to file appropriate application before the adjudicating authority for his fee and expenses full stop without interfering with the impugned order. The appeal is disposed of accordingly full stop. This is an application praying for continuation of 58 days delay in refiling the appeal full stop. Learned counsel for the appellant submits that after filing of the appeal, defects were marked and appellant took some time in curing the defects. It is submitted that certain affidavit was required from the appellant in which some time was taken full stop. Learned counsel for the respondent opposed the application and submitted that application shows casual and neglecting approach of the appellant full stop. We find that sufficient cause has been shown to condone 58 days delay in refiling the appeal full stop. Delay condoned full stop. IA number 5723 of 2025 is disposed of full stop. Hired learned counsel for the appellant and learned counsel for the respondent full stop. This appeal has been filed against the order dated 20th 5 2025 by which order the adjudicating authority has rejected section 9 application filed by the appellant full stop. Appellant's case is that it has issued various invoices and issued a demand notice dated 13/8/2029 with regard to work done full stop. It is submitted that after giving the demand notice, Section 9 application was filed bearing CPIB number 3392 of 2029 in which reply was filed full stop. The adjudicating authority heard the appellant by the impugned order dismissed the application on the ground that the demand notice which issued by the appellant has not been served on the corporate debtor full stop. The adjudicating authority has noticed that the demand notice which was sent was returned with the endorsement addressee has left full stop. The adjudicating authority came to the conclusion that when articles sent were returned with remark addressee has left and no subsequent service was effected, Section 9 application cannot be admitted full stop. The said observation has been made by the adjudicating authority in paras 13 and 14 of the judgment full stop. We do not find any error in the order of the adjudicating authority rejecting the Section 9 application on the ground that demand notice has never been served full stop. Learned counsel for the appellant sought to contend that the said notice was also sent by email, which submission is denied by learned counsel for the respondent full stop. However, as the above issue was never raised before the adjudicating authority, the said submission needs no consideration in this appeal full stop. We thus are of the view that the adjudicating authority did not commit any error in rejecting the Section 9 application on the ground that demand notice has not been served to the corporate debtor full stop. However, it shall not preclude the appellant to file fresh petition after serving demand notice in accordance with law. Stop and over.